Good morning, everyone. My name is Sarah Mansour. I'm General Counsel at Mazda Canada and also a board member of the Association of Corporate Counsels Ontario chapter. The ACC is a global organization of in-house counsel for in-house counsel. For those of you who are not members, ACC has chapters in Quebec, Ontario, and BC. In Ontario, we are so proud to have over 800 members representing over 250 businesses throughout the province. Today's program has over 500 participants, 100 of which are ACC members. If you aren't a member yet, we encourage you to join us. With that in mind, this program was developed in collaboration with the ACC and Dentons to reflect the practical needs of our members. The role of in-house counsel, we know, is no longer what it used to be. We are expected to do less with more, keep up with the continually changing space of privacy and class actions, and what is going on south of the border. As corporate counsel, we always want to be mindful and consider the cross-border nature of legal issues when advising our stakeholders and how that may impact our organization. We hope you can walk away from today's presentation with some practical advice on managing risk and how to better service your stakeholders. A special thanks to our speakers today, the Dentons team, and Christina and Aviva. Enjoy the presentation, and Matt, over to you. Thank you.
Thank you, Sarah, and thank you to the Association of Corporate Counsel Ontario and its members for joining us for today's session, Leading Privacy from Within, Embedding Compliance and Managing Risk Across Borders. My name is Matthew Fleming, a litigation partner at Dentons in Toronto. My practice focuses on complex commercial disputes with an emphasis on class actions. The litigation landscape continues to evolve in the areas of privacy litigation and class actions. And as the role of in-house counsel continues to expand, you are no longer just legal advisors. You are strategic partners shaping business decisions and outcomes. That is why we developed this program, to give you actionable insights at the intersection of law and business operations so you can mitigate organizational risk and implement best practices effectively. Today, we're joined by an exceptional panel offering both cross-border and in-house perspectives. Emma Irving is a partner in Dentons Litigation and Dispute Resolution Group in Vancouver. Emma is the leader of the firm's National Privacy Class Action Group and advises both domestic and global companies on high-stakes litigation, including privacy breaches, data misuse, and tech-related risks. Peter Stockburger is the managing partner of Dentons' San Diego office and co-leader of the firm's autonomous vehicles practice. Peter advises companies on data privacy, cybersecurity, and emerging tech risks, including AI, algorithmic bias, and cross-border data compliance. He helps clients navigate privacy governance, security programs, privacy by design, and risks in M&A, product development, and workplace practices. Alexandra Quigley is a senior associate in our Montreal litigation and privacy and cybersecurity groups. Alexandra focuses on civil and commercial litigation with a strong emphasis on privacy. She regularly advises clients on consent issues, cross-border data transfers, authentication, and social media compliance across all industries. And finally, Shreya Gupta is the Director, Legal Counsel, Technology, AI, and Privacy at Loblaw Companies Limited. At Loblaw, Shreya advises on technology, artificial intelligence, privacy, cybersecurity, and information governance matters. Prior to Loblaw, Shreya was a technology lawyer at a global law firm in their Toronto office and also served as acting general counsel on secondment at 7 Shifts Inc., a team management software provider. She is passionate about training the next generation of business and legal leaders and often acts as a guest lecturer for law and executive MBA students. As our guest panelist today, Shreya will be the voice of in-house counsel. To get things started, I will now turn it over to our speakers to provide an overview of the privacy class action landscape in both Canada and the US, and to tell us a bit about how the landscape has progressed over time and where we are at today. Let's start with Emma for the common law provinces in Canada, followed by Alex, who will review the landscape in Quebec, before going to Peter for an update on the United States.
Thanks, Matt. So in Canada, plaintiffs traditionally rely on a number of different sources of law when it comes to privacy class actions. In particular, there's provincial privacy statutes, which can obviously vary between the provinces. In some provinces, they can rely on the tort of intrusion upon seclusion, though, as I'll get into, that's becoming more difficult for them. And as well, consumer protection laws in the provinces can also play onto the issues of privacy breaches. And in some cases, depending on what mechanism they're using, they don't even need to prove the traditional financial losses. They can secure moral or symbolic damages through some of the different causes of action. Now, historically in Canada, what we saw was that privacy class actions were traditionally data breach class actions. In particular, you would have a custodian of data who suffered a breach due to a hack by a third party. And it was the custodian of the data who was being sued because they're the ones who are in Canada who can be identified and have the money, essentially. And initially, Canadian courts applied a broad and liberal approach to certification of these types of data breach cases. It was at the point where most of them were just being certified. However, courts have become increasingly more skeptical, and they're starting to scrutinize these claims more heavily, which has made it increasingly more difficult for plaintiffs to achieve certification in traditional data breach cases, particularly ones where there's no real damage, no out-of-pocket expenses that have been incurred by the plaintiffs. And as a result, what we've seen is that some class action lawyers are trying to shift tactics, and rather than targeting data breach cases, particularly by external actors, they're pursuing claims that focus on how companies themselves are handling their own data, specifically alleging that businesses are misusing or improperly collecting their customers' information in ways that violate privacy rights. And in particular, we started to see the shift coming out of 2022 when there were some changes in the law there. So prior to 2022, one of the key factors behind the prevalence of data breach cases in Canada was that plaintiffs could use what's called the tort of intrusion upon seclusion, which is a common law tort that allowed for a claim when a company was alleged to be intentionally or reckless intrusion into a plaintiff's private affairs without lawful justification. And this type of legal claim was particularly advantageous because it allowed for liability and damages without actually requiring proof that the plaintiff experienced actual harm. And by that, I mean out-of-pocket expenses. But the landscape started to shift in 2022 when the Ontario Court of Appeal issued 3 key rulings that narrowed the scope of intrusion upon seclusion. In particular, the court found that companies whose databases were breached by a third-party hacker, they could not themselves be held liable under the tort because it was the external actors, the hackers, not the companies themselves, who had intruded upon the privacy of the customers. And this interpretation was then confirmed by the Alberta Court of Appeal. So this was the law in both Alberta and Ontario. Plaintiffs in those provinces could still bring a claim under negligence, but the problem with negligence is that it needed evidence that a measurable financial loss had been suffered by the plaintiffs. And it couldn't just be the normal irritation or upset that come with our everyday lives. It had to be something more. So this made it much harder for plaintiffs' counsel to certify class actions against the custodians of databases that have been hacked in these types of provinces. British Columbia took a slightly different approach. The BC courts did confirm and agree that the tort of intrusion upon seclusion cannot be applied against companies that have been victims of hacking. But BC's Provincial Privacy Act still created a statutory cause of action in data breach cases that didn't require proof of damages. Now, that doesn't mean that the courts in BC were still rubber stamping data breach cases because there was still skepticism regarding whether this was really worth the mechanism of a class action if there was no real damages, but it did leave the door open to those types of claims there. So as these traditional data breach cases have become more difficult to certify in Canada, there seems to be a shift going towards looking at how companies themselves are using their data. And it's either the companies, how they're using the data that they collect, or if they're transferring or disclosing that data to a third party, even their own contractor or vendor, what that third party is doing with the data, and whether that is in breach of people's privacy rights. In particular, one of the big areas we're seeing about this is something called scope creep with consent. So someone gives data, they give consent for that, and then the plaintiffs' counsel are looking at what ultimately was done with the data and whether it was within the consent that was given. We're going to get into this in more detail later in the presentation, but this is definitely an area to watch, particularly when companies are not just using the data themselves, but they're giving it to third-party vendors. And with that, I'm going to pass it over to Alex to talk about Quebec.
Thanks, Emma. So in Quebec, the threshold for authorization is fairly low, which can make it easy for plaintiffs to initiate proceedings. And so, as Emma was describing for other provinces, Quebec has also seen a growing number of class actions relating to the misuse or mishandling of personal information. So, as Emma alluded to in other provinces, this can have a link to overcollection, unauthorized sharing, and improper management of sensitive categories. So, under the Quebec Private Sector Privacy Act, we have a definition of sensitive personal information. What it specifically includes biometric data and health data, which is what we're seeing a lot of issues surrounding either litigations or class actions in Quebec. With new obligations under Law 25 that came into effect a few years ago, class counsel are expected to increasingly rely on this legislation to support their arguments. So this means that in Quebec, combining a low barrier to class action authorization, new provisions, there will likely be an uptick in data misuse handling class actions. What do we mean by data mishandling or misuse in terms of allegations from in terms of class actions, or generally speaking? What we see is a lot of issues raised with how organizations are using data, how, like Emma said, we'll touch on this later with consent creep, whether they're actually respecting the necessary and initially outlined uses of personal information, and also retention periods and use. So in a recent decision in the Capital One case, which has to do with authorization, this is on the merits, but here there were allegations relating to how various companies had used personal information in the context of a breach caused by a third-party bad actor. Now, even though the third party is responsible for the breach, it brought to light potential issues relating to retention periods, whether or not a company had properly deleted or misused its information, and so on. So what we want to do here is pay attention to your ongoing privacy compliance, the policies, proactive data protection measures. What you're doing daily could actually be useful in the context of defending against a class action, even though that may relate or may stem from a breach, or in Quebec, what we often call a confidentiality incident. Another interesting point coming from that Capital One case is the Quebec Court of Appeal noted that a representative's personal case does not have to be typical of most of the members. And so a representative only demonstrates sufficiently that they suffered at least one type of damage that is alleged in that class action and has to do with that. So we often see are credit monitoring fees, whether there were actual losses stemming from data breaches and so on. All of those do not have to be applicable for your class representative, it seems, at least at the authorization stage. The representative only needs to have suffered one. So that also points to that lower threshold in Quebec, which could lead to increased risk or vulnerability for various organizations. And with that, we'll be sending it to Peter for the US landscape.
Great, thanks, Alex. I appreciate it. Not surprisingly, the U.S. landscape sort of has a similar history to Canada in terms of really starting out around data breaches and security litigation. But I think the U.S. has deviated and has gotten a lot more litigious around things like digital privacy with regard to cookies and pixels and biometrics. So I think to understand the U.S. trends, it's important to have a level set about how U.S. data privacy law actually operates. We do not have a federal U.S. data privacy law that's applicable to all 50 states. Instead, similar to Canada, we have a patchwork. We have a patchwork of federal laws that largely apply to different sectors, and then we have a growing patchwork of state laws. So at the federal level, for example, We have a law called the FTC Act, the Federal Trade Commission Act, that regulates unfair business practices. So this is a law that applies to most companies that are doing what's called interstate commerce, and it regulates companies on engaging in unfair or deceptive business practices. And historically, the federal regulators have interpreted that to mean if you don't maintain reasonable security around personal information, you could be held accountable under the FTC Act. If you make a promise in your privacy statement, your privacy notice that's incorrect or misleading, you could use the FTC Act as your hammer. And litigants, plaintiffs' bars, have been using the FTC Act for years to allege negligence or breach of contract claims by making misrepresentations in the privacy policy. We also have sectoral laws at the federal level. So we have the Children's Online Privacy Protection Act, COPPA, that regulates how you collect the personal information of kids under the age of 13. We have HIPAA that regulates health data. We have the Gramm-Leach-Bliley Act that regulates financial institution data. So highly sectoral laws, no uniform federal 50-state privacy law. At the state level, we see even more divergence. Historically, state privacy laws for years were really found in common law intrusion upon seclusion or invasion of privacy claims. So similar to Canada, that sort of standard statutory claim that sits there that can be broadly applicable to things like recording somebody in their house or in a bathroom. And there were also these constitutional rights of privacy at the state level. For example, in California, where I'm based, we have a constitutional right to privacy that plaintiffs' lawyers will often throw in when they're doing a kitchen sink style class action. But really where we've seen the most movement in the US, I would say over the past 5 years, is in the areas of biometric litigation, but also in the areas of cookies and pixels. So on the biometric side, we have several US states that have very strict laws regarding how you can collect and use biometric information and biometric identifiers. And biometric information and identifiers are broadly defined to include things like facial geometry, iris scan, fingerprints. And so there's been a wide array of litigation in states like Illinois. There's a new law in Colorado. California has seen some litigation regarding how employees use fingerprints for scanning in their timekeeping systems, how employers use facial recognition to log into computer systems. So there's lots of allegations and litigation around biometrics. I would say that has started to wane over the years because the courts have reined in the plaintiff's bar with regard to the types of damages that you can claim. I think that the fastest growing area of class action litigation in the US with regard to privacy are areas around third-party technologies, both AI and also cookies and pixels that are being deployed throughout businesses depending on the industry. So I'll start first with the website litigation, which if you haven't received a demand letter yet from a handful of plaintiffs' lawyers in the US, consider yourself lucky. You could be on the receiving end any day now because these plaintiffs' firms are sending out demand letters, class action complaints by the thousands each month against every company you can imagine, from mom and pop startup to Fortune 10 companies. They're getting the same demand letters. And the allegation is that by using third-party marketing or advertising cookies or pixels on a website or on a mobile application or embedded in an email, that constitutes third-party eavesdropping or wiretapping of a communication between the consumer and the business. Most states like California have laws on the books that have been around for decades that require dual-party consent to record a conversation between Party A and Party B. And the allegation is that when a consumer lands on a website and they type something into the search bar or they click a link on the page, that's a form of an electronic communication between the consumer and the business that owns the website. And the allegation is that by allowing things like Google Analytics or the Meta Pixel or the TikTok Pixel or the Pinterest Pixel, all of these advertising tools that are prolific across websites, that's a third party coming in and reading the electronic communication, recording it between the consumer and the business. That's the core of the allegation. And there's lots of different variations of it. They allege the use of chatbots. is the same thing. There's a new wave of lawsuits around AI tools, alleging that the AI chatbot or the AI call center is also a third party that's engaged in wiretapping, eavesdropping. A new trend right now is alleging that that same type of technology constitutes a pen register or a trap and trace device, which is what law enforcement uses to track incoming and outgoing telephone calls when they wiretap for a criminal investigation. So the plaintiff's bar is very creative in this space. And what it means, bottom line, for organizations is that if you have a website, if you have a mobile application, or if you use pixels in your commercial emails, and you have marketing and advertising cookies or pixels, regardless of the type, you are in scope to be hit with one of these class action demands. And they send these demand letters. Sometimes they file the lawsuit immediately. Sometimes they file in arbitration. And you might be thinking, well, how do I protect against this if it's so prolific? I think there are some key prophylactic measures that organizations can take. One is carefully look at your cookie banner and what you're saying about the types of third parties you're using. Are you obtaining consent from the user? Are you not obtaining consent? Consent is a defense to a lot of this litigation. And how are you actually firing off those cookies and pixels on various pages? So you've got to get real granular with how the tech is operating. But this is probably the hottest, the fastest, the most expensive area of class action litigation in the US from a privacy perspective. And I'll just end with this. We've got, you may hear about the US privacy laws. We've got 18 states with very robust privacy laws like the California Consumer Privacy Act and laws in Colorado and Virginia and Texas and Nebraska. These laws impose compliance requirements on businesses that are covered, like having a valid privacy policy, extending data privacy rights like right of access, right of deletion, right of correction to consumers of those states. The good news is that none of those laws have a private right of action. They can only be enforced by the regulator in those various states. So largely that's the Attorney General of a state. California is unique. We have both the Attorney General enforcing our law as well as an agency called Cal Privacy that can enforce the law. So think of it like a DPO in Europe, a Data Protection Authority in Europe. Now, there is one exception to that, and that brings us back to the data breach area, and that is the California Consumer Privacy Act. It does allow for a private right of action if you've had a data breach and it was the result of negligence. So if you were not maintaining reasonable security and it was your fault, you did something that was deemed negligent, the CCPA can be a vehicle to come in for a lawsuit. And the reason why that's important is because the CCPA carries with it a penalty of $2,500 per violation, which can be down to the per data point exposed per consumer, up to $7,500 if it's deemed intentional and there's no cap. So we haven't seen real heavy litigation on the class action side with regard to a data breach under the CCPA. We have seen enforcement actions in that space, and we're now seeing enforcement penalties in the millions of dollars for things like not maintaining a proper cookie banner. But I would say in the litigation space, where most of the energy is right now, where most companies are going to feel it, is in the area of third-party cookies and pixels on the website, in using email, and if you are engaging with emerging AI technology in the areas of a call center, in the areas of a chatbot, anything that's consumer facing, those are really where we're seeing most of the action. Matt, I'll toss it back to you.
Thanks, Emma, Alex, and Peter. So now that we have set the stage to understand current trends, let's shift the focus of the discussion to future trends you expect to see in this space.
Thanks, Peter. Thanks, Matt. So I can jump on that maybe first with the trend towards the misuse of personal information. So what we're seeing is that typical or ordinary data practices are now being reframed or presented as misuses of personal information in the context of class actions and general exposure risk. So tracking technologies, online advertising, cross-site cookies, these are kind of hot button topics that even though an organization's practices may be market, they could also be tagged as potential misuses. So something that we often see, for example, and we warn our clients about frequently is, for example, given the broad definition of what is a data breach or a misuse, typical issues that can stem could, lead to potential liability. So for example, if you're keeping personal information beyond the period that you've identified in your retention policies, in your privacy notices, etc., you are in a situation where you are misusing personal information, and creative counsel on the plaintiff side could view this as a misuse and potentially file a class action. So these are things that you want to look out for. Especially, I say this in Quebec because organizations typically don't think about this, and we often see some spirited debates between in-house counsel and marketing teams and other teams of your organization, which has to do with tracking. The Quebec requirements are not necessarily market with privacy notices, consent requirements, prior notices and access, and so on. So these are things that you want to consider ahead of time in order to make sure that you avoid unnecessary risk. While courts have become more demanding on certification and harm, we see that plaintiffs continue to push their novel theories and approaches about disclosures, data use, and so on. So once again, you want to make sure that your practices and your ongoing approach to privacy requirements align with what you need to do in terms of legal treatment and so on. What you also want to do is be aware of documentation, risk assessments, and other points to make sure that you keep an eye on that. Please keep an eye on your privacy impact assessments, your PIAs. Communication strategies must be considered before they go on. All of these elements are important to avoid being accused or being found liable in terms of the misuse of personal information.
Yeah, Alex, I can jump in from the US perspective too. I think three areas that are emerging right now. One around technology supply chain. So a growing area of cybersecurity risk, which can trigger the class action risk on the data breach side, is the expansive nature of the technology supply chain. So many organizations in their own cybersecurity function are using vendors on top of vendors on top of vendors to deliver certain services, to give access to certain databases. And we've seen an increase in the cyber bad actors not targeting the prime business, but targeting the vendors underneath the business. And therefore, once they get in through that back end, there's an exposure. So I think that's an increasing trend. The second trend we're seeing on the US side is this move toward requiring consent. So the US is really a notice jurisdiction. Just tell people what you're doing with their data and you can do it. There's no requirement to obtain consent largely. That's starting to shift in the regulations that we're seeing. For example, in California, there's a rule that says if you're using someone's personal information beyond what a reasonable consumer would expect, you need to obtain their opt-in consent. Other state privacy laws say that you need to obtain consent if you're collecting things like health data or the data of children under the age of 18 or data relating to biometrics or precise geolocation data. So the scope of consent, I think, is something that's new in the US and is increasing. And then finally, I do think AI is really probably one of the fastest growing areas of risk in the US. And the major risk to consider with AI here is the presence of third parties and making that clear to the consumer, to the employee, that a third party is present. But also, what is the liability shifting that adds in with vendors on the AI side? And I think there's an important case to watch in the US right now. It's not a privacy case per se, but it's a case going on in the Northern District of California involving an individual named Mobley and the company Workday. And Mobley alleges he was over the age of 40, African American, had a physical disability, and he filed a lawsuit against Workday alleging age discrimination, racial discrimination, disability discrimination under federal law. And Workday said, we're not responsible under these laws. These are discrimination laws for the employer. The employers are responsible. Our tool that scans resumes is just a tool. We're just a vendor. And the plaintiff alleges that their tool was trained on a non-diverse data set. Therefore, the tool resulted in discriminatory outcomes. And recently, over the summer, Workday moved to dismiss that case, and the court said that there were enough factual allegations to allege that Workday was liable as an agent of the employer because Workday maintained a certain level of control over the output and the decision making. And now that case is moving forward. There's conditional certification and they're in a discovery battle. But even though that's not a privacy class action, I think that case is important to watch because if the finding is that maintaining control over the output and how the output is used by the vendor is determinative of federal agency under federal law, you will start to see more vendors sort of push back onto the company liability shifting because in the area of AI, one of the emerging technologies is known as agentic AI. And this is AI that can make decisions on its own, access databases, engage with customers, make decisions without human involvement. And so vendors who are controlling that process, they may be taking on more liability. And I think there's going to be a real push-pull in the AI vendor space emerging over the next 12 to 18 months that we haven't seen yet. So if you don't have a good AI contract right now, now's the time to get that locked in because I think that space in the US is emerging quickly.
Hi, everyone. I'm happy to jump in on the technology supply chain piece. So Peter mentioned there is an increased focus on the technology supply chain, and maybe we can double click on that a little bit. So historically, if I take you down a memory lane, technology supply chains were fairly simple, right? When we think of the supply chains, we really think about products that are, or food on our table. But historically, as a community, I'm not sure if we've really talked about the technology supply chain. With the introduction of cloud, that became increasingly complicated. And now with AI, it really is an area of focus. So when we think about where a business might be exposed in the coming years, understanding the technology supply chain, when you're procuring a product, when you are part of that supply chain as a vendor, what your true role is on that line is very, very important. Understanding the scope and scale of not only just the data, but the impact of the audience is very important. So Peter mentioned biometric, health-related data, financial data, but also really thinking about your audience. At the end of the day, if you're a customer and you are procuring a product, what is it that you're procuring? Yes, it's about that software. It might be about consulting services, but who is going to be impacted at the end of the day is going to really drive the exposure down the road. So thinking about that, also considering, is it an internal technology, right, that you're leveraging, or is it going to impact external customers or use cases? At the end of the day, the exposure really comes from scope creep. So if on the front end, there is a lack of clarity or maybe a number of assumptions that are being made when it comes to where a company or a vendor or a customer is on that supply chain, it might result in scope creep. And scope creep is hard to control, right? So getting ahead of that becomes extremely important and asking questions. At the end of the day, as in-house counsel, let's not be afraid to ask those questions, because once we ask those questions, as my fellow panelists have mentioned, then we know who the third parties are, right, in the relationship, and who the other players are that might be informing how you're exposed, or if you're exposed at all.
Thanks, all. So with all of this in mind, let's focus on the practical aspects for what these and related issues mean for in-house counsel. Shreya, could you walk us through the checklist of items that in-house counsel should be thinking about heading into 2026?
Sure. Thanks, Matt. So I have a really strong appreciation of being in-house, right? Sarah mentioned it very clearly from upfront. We are expected to do more with less. And with that in mind, it means the first priority item, and this is not on the checklist, but is incredibly important, is upskilling, right? And we'll walk through some of those practical items, but upskilling to understand technology, to understand the various areas of privacy for other implications is really important, even if you're not traditionally a privacy lawyer or a technology lawyer, right? At the end of the day, if you're not, even if you're not developing technology, even if you're not, developing data, you're not working with data, you are procuring technology. There's no escaping it, right? And that really comes with the importance of understanding what you're procuring. So let's talk about priorities over the next 6 to 12 months. What does this look like as in-house counsel? Number one, thinking about compliance before the contracting stage. What does this mean? In my view, contracting is really that gateway, right? So if you're a customer, you might have a whole process around assessments, understanding the risks associated with procuring that technology. If you're a vendor or if you're a company developing technology, that assessment process may be inbuilt. But typically, for a customer or a vendor, you might be thinking about the contracting stage as just a hurdle or a hump to get over. But really, we need to consider what the contracting stage is about. And what it means is, number one, understanding the use case, right? So thinking about, let's say, take AI. AI's hit everybody, really, really with lots of considerations. But think of it as just a tool. So it's not about the fact that it's AI being leveraged, but more about how it's being leveraged. Again, who is impacted and what is the risk profile and who should be taking on what risk? All of that can be done at the contracting stage. This has an incredible impact on down the road, a potential class action, for example, right? Because of the broad implications of a use case, or maybe the use case isn't as broad and leveraging a tool, right, a technology like AI, not a problem. So the compliance prior to and during the contracting stage becomes really important. Then you can align on risk allocation, whether that's internally with your control functions or it is with the vendor, right? Because the vendor should be responsible for X things versus yourself. The next element to think about is categorizing the risk. And I think that becomes increasingly challenging with technology becoming increasingly challenging, right? The risk may not be a data-driven risk, right? The risk may be something that's IP-driven. It may be something that is purely reputational. And I think at the end of the day, really distilling it down to the use case and understanding what the role is, what the use case is, what the data might be, what the impacted audience might be, is really, really important, because then as in-house counsel, you can actually frame the risk for the business rather than just flag, hey, this data is implicated or perhaps not implicated. So identifying and categorizing the risk becomes increasingly important as you're navigating the next 6 to 12 months. Data governance. So data governance has been top of mind, especially with new emerging technologies with AI. But what does that really mean? Data governance is not really a one-size-fits-all. So a few triggers to keep in mind. Over the past couple of years, there has been an increased shift when it comes to technology vendors, for example, on use of personal information versus anonymized aggregate information. And so the reason with increasing use of AI or emerging technologies, data governance becomes important because it's not necessarily just about the fact that it's personal information. We have to also, as in-house counsel, consider, are we okay with allowing a certain use of anonymized aggregate information, right? It's not just about identifiability, but re-identifiability. So consider those impacts and internally consider how to manage that risk. In the next 6 to 12 months, you might decide based on your organization, you have certain governance processes already, and it's a matter of upskilling those processes, right? With AI, it doesn't necessarily mean you have to stand up a whole new process, a whole new process in terms of stakeholders, in terms of alignment. but you might need to upskill different stakeholders, right? You might need to upskill your current processes to catch that incremental consideration that comes with leveraging new technologies. From a vendor standpoint, keep in mind, again, who is the vendor? What are they offering? It's not necessarily just about the fact that they're offering AI solutions, right? But is it a professional services firm using AI to provide you with services or a deliverable? Those risks are going to be very different, and how you address those risks, right, and how you manage those risks are very different from a software or SaaS provider, right, that is leveraging artificial intelligence either as core to their service, or maybe it's more of a back-end machine learning thing, right? Very different process and very different risk allocation. Or is it just that you've got employees leveraging artificial intelligence, right, or free tools, right, within your system? Also very different. So data governance is no longer just personal information. It's no longer just one type of vendor. It's kind of been upskilled to include what's happening with your data throughout the organization. So that brings us to incident response and readiness. I would say a decade ago, cybersecurity incidents were more an if, right? Now it's more of a when. So anytime if you're negotiating with the vendor or you're considering internally, if the conversation and the risk allocation conversation comes up with respect to like, if this happens, there's a need to maybe reconsider, right? Because it's no longer an if, it's a when. So given what you're doing, given the use case, consider when there's unauthorized disclosure, what would be the impact? And then you work backwards from that, right? So if the impact could be reputational, could be regulatory, could be a privacy class action, for example, right? How do you mitigate that risk? Do you mitigate it contractually through controls? Usually a combination of the two, right? So considering incident response and readiness is important. Also, one of the trends that's very important to keep in mind is the difference between an incident experienced by your own organization versus a third-party vendor or partner, and how the processes and the response differs between the two. In the industry, we've been very focused on how does an organization deal with its own, cybersecurity incident. But what happens when you're notified of an incident, right? When somebody else was processing your information, whether it's privacy driven or just confidential information, how do you respond to that? Because that is going to be governed by your contract, right? So if at the front end, your contract doesn't contemplate those potential risks appropriately, you might not have a line of sight into how that incident is being dealt with, and might not have the right to some of that information that you truly might need as an organization to respond. Vendor risk and AI management. So one of the triggers to keep in mind is whose privacy policy applies, right? So privacy policy traditionally has been, this is the privacy person's thing to review. Now with the increased use of technology, with a lot of or majority of commercial agreements leveraging technology in one way or another, linking multiple privacy policies or your contract saying, both parties' privacy policies apply may require additional deep dives, right? At the end of the day, understanding what that privacy policy says, what the use restrictions are between the parties, how can the parties use the data is very important, but even your own privacy policy, because at the end of the day, it's about the consent. If you are the data custodian at the end, then understanding what consents you have from the ultimate data subject, whether you can even permit use by a third party, right? And then flowing that down to what needs to happen to conduct business. We want to make sure that we enable our businesses, and we want to make sure we leverage technology, but really seeing it from A to Z and the whole supply chain becomes incredibly important. I'll end on one last note, and that's about culture. So as I mentioned, every lawyer, especially if you are in-house, almost needs to become a technology lawyer. And that's because technology is so deep-rooted in our how we conduct business, right? It's like saying, especially with the introduction of AI, it's like saying the internet's here, or the emails are here, but we're going to use pigeon mail, right, to kind of conduct business. So AI is here to stay, right? New technologies are going to evolve at a much faster rate than our laws are going to evolve. We have a foundation in terms of consumer protection laws, other laws, and human rights, right? We have a foundation built in there. We, of course, unfortunately, from a Canadian standpoint especially, don't have any regulations to rely on yet. But in keeping sort of in mind with that, it's really important to still be able to leverage our current laws, leverage what's right at the end of the day, and think about how do you allocate risk. And all that comes down to, at every stage of your life cycle, how do you identify risks, frame risks for the business, not just flag, frame it, right? And then find different ways to mitigate it. The culture at the end of the day needs to be one of evolution. So we need to be able to move fast, move quickly, and be really practical. Call me a pessimist, but let's not wait for the AI specific law in Canada, especially to drive our compliance, to drive our advice. But look at, okay, what can we do already to set ourselves up for the next few years?
Thanks, Shreya. That's a great practical checklist. And just to kind of emphasize what Shreya was saying from Canadians' perspective, it's really important that companies who collect and hold data are really looking at the issues of consent. When people give you your data, there's a consent that's given, but it's generally for specific use, or maybe a broad consent, but it's important to know what the consent was and what can be done with the data, as well as looking at those supply chains. And if the data is being disclosed or transferred to a third party, what are they doing with it? And just before we kind of move on this time, just to give you kind of a couple of examples to give a bit more context or real life context to this. There was a case in British Columbia against a tech app called Flow Health, and it was designed to help women track their periods and their cycles. And what they did was they had actually got people's consent to give them sensitive information. And the consent said, it was only going to be used for certain things, and it was only going to be provided to third parties for very specific purposes, including developing the app. But what they did was they then entered into agreements with like Facebook and Google and a few other third-party tech companies and just clicked and accepted their standard terms of service without really doing that analysis as to what those standard terms of service said those third parties could do with the data. And as you can probably imagine, Facebook and Google have very broad terms that, roughly said they could do anything they wanted with data that was transferred to them. And this is fairly sensitive data. So when it was transferred and used by the third parties, that was beyond the scope of what the consent had been given when the data had been provided. And ultimately, they ended up in a class action over it. And so there was a really important case in the sense of these third parties that you're contracting with, that you're actually scrutinizing how that chain is working and whether it falls within the consent that you've given. And it doesn't always have to be particularly what we consider more sensitive information, like financial information or health information. And it's also important, not just when you give data to third parties, but if companies are using the data themselves. Sometimes they collect data for one purpose, and that's what the consent is suggesting. But then they take the data, it could be a year later. Someone comes up with another idea as to how you could use the data. And it's important to go back and look at the specific consent that was originally given. For example, Home Depot ended up in some hot water in a class action over the collection of emails. They had collected emails in order to provide electronic receipts, and they had consent then. But then later somebody came up with an idea of how else they could use those emails in a marketing context. But that wasn't the consent that was given. And while emails are not particularly sensitive, I think, it's something they probably would end up in a phone book today if we had them. It still went back to what was the consent, and they still ended up facing a class action over it. So it's important to keep in mind that you're constantly looking back. If you decide to use data in something else, go back. What was the consent that was given? If data is being transferred or disclosed to a third party, what are they going to do with it? And what have you agreed to allow them to do with it? And it's an ongoing process. Privacy laws are also changing. So it's something to you have to keep on top of as we go through, the next several years.
Yeah, Emma, I wanted to jump in there because I think that issue of consent creep or how do you manage consent is actually really critical on the US side as well from a practical checklist perspective. One of the most effective tools in the US in mitigating against a class action being filed is having a set of terms and conditions that include a class action waiver and an arbitration clause, where if there's an issue with third-party cookies, if there's an issue with you misused my data, do you have an effective contract in place, terms and conditions on your website that you can enforce in U.S. courts that you can include a class action waiver? And the U.S. courts, there's a lot of litigation around what constitutes an effective and enforceable agreement. And increasingly, to your point, Emma, the courts are looking at, are you obtaining consent for the terms and conditions separately from other documents? Are you clearly laying out at the point of consent that there's an arbitration clause? Or are there class action waivers? And this is a very unique US animal. I know most of the rest of the world does not like these types of clauses, but it is a very effective tool in the US. And another just practical checkpoint I wanted to highlight here was around third-party diligence. This is critically important right now in the US to mitigate risk. Do you know which third parties are operating on your website? If you don't, right now you can right-click on your website's homepage, click the inspect function, and you can see all the list of third parties operating in the background. Have you told the consumer what is happening on the website in such a degree that you can defend against one of those class actions? On the AI side or on the tech vendor side, do you know what they're doing with your authentication data in their databases? Do you understand what type of model they're using, how they've trained their model? Are you preventing against discriminatory outcomes? California's new AI regulations that take effect in 2027 specifically say you need to show proof that you vetted with your vendors their anti-bias testing. I'll leave you with this, the recent Salesforce data breach issue, where it wasn't an attack on Salesforce itself or the customers who use Salesforce. It was an attack on a third-party vendor that connected companies to their Salesforce instance called Sales Drift. And the bad actors got into the GitHub repository of that vendor, got the source code to get into the AWS bucket, and then pulled an authentication token for the customer, then got into the Salesforce database to then pull out data on their customers. So it was an example of a vendor being compromised and the customers not asking the vendor deep enough questions about how they encrypt data at rest, how they encrypt data in transit. So this issue of third-party risk management, it's becoming critically important on the US side because the bad actors, the plaintiffs bars are looking at the third party as the soft underbelly, I think, of the tech ecosystem.
Thanks, Peter. Just before I pass it back over to Matt, I just want to quickly jump in. I appreciate that arbitration clauses and class action waiver clauses are a great tool in the US. But if anyone in Canada is listening and thinks that's something that they might be able to utilize in Canada, I do want to caution you. Most provinces in Canada do not enforce class action waiver clauses or arbitration clauses against consumers. And in particular, British Columbia doesn't anymore. Ontario doesn't. And so you just have to be a little cautious around that. That is something that we used to use in Canada to defend against these cases, but they're increasingly unenforceable, at least when it comes to consumers. Thanks.
That was a great discussion. Thank you, Shreya, for the very practical and helpful real world tips, and Emma and Peter for jumping in with your thoughts as well. We don't have much time left, but we do have a couple of questions in the chat. I don't know if we'll get to all of them, but maybe we'll start with one. Just Peter, in the remaining time, for businesses looking to harmonize a global privacy program to address the complications in privacy compliance and emerging litigation, what are some key tips and strategies that you've seen that work across clients?
Yeah, I say it is very challenging to, if you are a global business or even just doing business in Canada, in the US, to develop a privacy compliance program that hits all of the bells and whistles. Very hard to be 100% compliant everywhere. But I do think that there are themes across each of our jurisdictions that are important. Be clear and upfront to the consumers. Whatever you have external facing, whether it be your privacy policy, your cookie banner, your statement at the point of purchase, are you being clear? Is it defensible? Are you hiding the ball? So, Emma, the issue on data misuse cases or consent flow, are you being clear? I think that's going to be true across all jurisdictions. Obviously, there's nuance in what type of rights are available, how you exercise those rights, the timing on responses. But the baseline principles of being upfront, obtaining consent where you think it's appropriate, maintaining reasonable security controls. And by the way, reasonableness with regard to cybersecurity, it's not going to vary that much across the countries. Encryption is encryption. They don't care if it's in Canada or the US. So I think understanding those nuances around data transfers and how to exercise rights are important. But Matt, I think there's a way to build a privacy program where you hit 80 to 90% of the common themes, and then you reserve that remaining 10 to 15%, if I'm doing my math correctly, on the jurisdictional nuances, the consents, the specific data privacy rights. So it's something we do with clients very often, but it's a real challenge, I think, for global businesses in today's sort of patchwork landscape.
All right. Well, we have 2 minutes remaining. A very thorough and I think practical discussion. So thank you to all of our presenters. And thank you to everyone who has joined us today. We hope you found the insights valuable and applicable to your day-to-day work. Thanks again. Bye-bye.